Starting with the introduction, whenever a person commits an act which is unlawful, that person is held liable for violating the law and thus he is punished accordingly. For example, A enters into the property of B without his permission. Such an act of A amounts to trespass and thus he is liable. This is the general rule of torts, but in some situations, a person can be made liable even if he has not done any wrong. If it is done by some other person with whom he shares a certain relation, such as master and servant or principal and agent, and in these cases, his liability is called as vicarious liability. Now, briefly understanding what is vicarious liability. Vicarious liability means the liability of a person for an act committed by another person, and such liability arises due to the nature of the relation between the two. For example, A, who is a driver who works for B, and while driving B's car for taking him to his office, he hits C, a pedestrian, due to his negligence in driving. In such a case, even though B was not driving the car, he will still be liable for the accident which was caused due to the negligence of A. Relations in which vicarious liability arises. These are the major relations in which vicarious liability of a person arises. Number 1, master servant. 2, partners in a partnership firm. 3, principal and agent. 4, company and its directors. And number 5, owner and independent contractors. Coming to the first point, which is vicarious liability in a master and servant relationship. In a master and servant relationship, the master employs the services of the servant and he works on the command of the master, and thus a special relation exists between the two. And in case of a tort committed by the servant, his master is also held liable. There are many cases in which the servant does an act for his master, and thus in law it is deemed that the master was doing that act himself. Therefore, if the servant commits an unlawful act, the master will also be held liable for the same. Liability of the master is based on the following two maxims. Number 1, qui facet alium facit per se. It means that whenever a person gets something done by another person, then the person is viewed to be doing such an act himself. For example, if A is the owner of many trucks and employs driver to drive them for the purpose of trade, and in case one of his drivers gets into an accident because of his rash driving, then even though A did not drive the truck himself, he will be liable for the accident. Number 2, coming to respondent superior. What does it mean? It means that the superior should be held responsible for the act done by his subordinates. These two maxims have played a very significant role in the development of the law of vicarious liability of the master. Next, coming to the essential of vicarious liability in a master and servant relationship. These essential conditions have to be followed for the vicarious liability of master to arise. The servant has committed an act which amounts to a tort, and number 2, such a tortious act is committed by the servant during the course of his employment under the master. Now, coming to the reasons. The reasons for liability of the master. There are several reasons behind holding the master liable for the acts of his servants, which are: number 1, an act which is committed by the servant is considered to be done by the master through him, and therefore, in the law of torts, it is assumed that if any wrong is done by the servant, it has been committed by his master indirectly, and so the master is held for these wrongs. Number 2, the master is in a better financial position as compared to his servants, and thus, in case of any loss caused by the tortious act of the servant, the master is better suited to pay off the damages to the victim of the act. Also, since the master is made liable, he makes sure that all reasonable care and precautions are carried so that he can avoid such liability. And lastly, when a servant does any act, the benefit from such an act is enjoyed by the master, and thus For the liability arising out of the servant's acts, the master should also shoulder that liability. Coming to the tests for determining master-servant relationship, we will be going to study about three tests, which is number one, traditional view, which is the control test, modern view, and lastly, multiple test. Starting with the traditional view or control test, as per this test for determination of the master and servant relationship, it should be seen whether the master has the power to not only instruct what should be done, but also the manner of doing the act, and if such power exists, then as per this test, the master and servant relationship exists between the two. Illustration: A is the owner of a big area of land on which farming activities are carried out, and he has hired many workers for farming. A not only instructs them how to do their jobs but also how to do it. Here, by the test of control, the relation between A and his employees is established as that of a master and a servant. Coming to the modern view, the old control test is not applicable as an exhaustive test because in cases of work requiring skill, such as a doctor working in a hospital, the owner of the hospital cannot instruct the doctor on how to treat a patient and can only instruct him to treat patients. Thus, certain other tests have been developed for determining the master and servant relationship. The test of work being an integral part of business. In the case of Stevenson Jordan and Harrison Limited versus McDonald and Evans 1952, the test of an integral part of the business was applied. Here, a contract of service was held to be a contract for such work which is an integral part of the business, and the contract for service was held to be a contract for such work which is not an integral part of the business. Illustration: in an IT company, the programmers are the employees of a company, and there is a master servant relationship. But if the company has hired catering service as well, the company does not have a master service relationship because the act of providing food is not integral part of an IT company. Next, coming to multiple test. This test provides that people who are in contract of service are deemed to be employees, whereas the people who are in contract for service are independent contractors. In the case of Ready Mixed Concrete versus Minister of Pensions and National Insurance 1968, three conditions were laid down for a contract of service. Number one, the servant agrees to provide his skill and work to the master for performing some services in exchange for wages or some other consideration. Number two, he agrees to be subjected to such a degree of control so as to make the person his master in performance of his work. And lastly, the other provision of the contract are consistent with the provision of being a contract of service. The view was also reiterated in the case of the management of Indian Bank versus the presiding officer. This test also includes other important factors that are used to determine the master-servant relationship, such as who owns the tools being used for the work, is the employee paid wages monthly or on a daily basis, and all the other relevant factors. Thus, the old way of using control test is no longer the only method of determining the relation of master and servant, as it has been realized that in the present complex world, where there are a wide number of factors which affect the process of determining the relation between the employee and the employer, it is not possible to use just one test, and thus the various aspects of a case are seen to determine the nature of the relationship and to decide whether such a relation is that of master and the servants or not. Then coming to difference between servant and independent contractor. A servant and an independent contractor both do the work at the behest of another person, and thus what shall be done is not decided by them but by some other person, and thus on the face of it appears that both are in the same category and a master should be liable for the torts committed by both of them. But there is a difference between the two which separates them, and consequently, while in case of tort by servant the master is liable, but in case of independent contractor the master cannot be held liable. In case of servant, there is a contract of service, which means that along with the instructing what tasks should be done by the servant, the master also has the right to instruct the manner in which that act has to be done, and thus the servant does not have autonomy in the performance of his duties. Illustration: P is the owner of a newspaper in which many editors are working. Here, P, as the owner, has the right of telling them which news should be covered and how it should be written. Whereas in the case of an independent contractor, there is a contract for service, which means that he is only instructed as to what should be done, but how to do the work is left at his will, and he does not take any instructions from the master. Illustration: If P is the owner of a newspaper and his machinery is damaged and he calls J to repair it, here P can instruct him what to do, but how to repair the machinery is left to be done by J without any instruction from P. Now, discussing the various ways in which the liability of a master arises. A master becomes liable in the following situations. Number one, wrong done as a natural consequence of an act by servant for master with due care. If the employee does an act which is done in pursuance of the instruction of the master, then the master will be held liable for any wrong which arises out of such an act, even if all due care is taken by the employee in discharging his work. In Gregory versus Piper 1928, the defendant and the plaintiff had some disputes between them, and the defendant therefore ordered his servant to place rubbish across a pathway to prevent the plaintiff from proceeding on that way, and the servant took all care to ensure that no part of it was touching the part of the plaintiff's property. But with the passage of time, the rubbish slid down and touched the walls of the plaintiff, and thus he sued for trespass. The defendant was held liable despite his servant taking all due care. Next, wrong due to negligence of worker. A master is also liable for an act of servant which he does negligently or fails to take due care in carrying out. In Pushpabai Purushottam Udesi versus others versus Ranjit Gainik and Pressing Corporation, deceased was traveling in a car driven by the manager of respondent company, and it met with an accident as a result of which he died. The dependents of the deceased filed a claim, and the tribunal allowed the damages on appeal to the High Court. It was set aside on the grounds that the accident does not make the responded company liable, but the Supreme Court in its judgment overruled the judgment of the High Court and held that from the facts of the case it was clear that the accident had occurred due to the negligence of the manager who was driving the vehicle in the course of his employment, and therefore the respondent's company was liable for his negligible act. Illustration: If H works as a house cleaner for K, then there is a master and servant relationship between them. But if H, instead of cleaning the house, decides to cook food, even though he has only been hired for cleaning the house, and due to his negligence causes a fire which also causes loss to K's neighbor L, then K will not be liable because H did an act which was outside the course of his employment. Wrong by excess or mistaken execution of a lawful authority. For making the master liable in such a case, it has to be shown that the servant had intended to do an act on behalf of his master which he was authorized to do. The act would have been lawful if it was done in those circumstances which the servant mistakenly believed were true, or if the act would have been lawful if done properly. In Bailey versus Manchester S&L Railway in 1873, a porter of a railway company, while working, mistakenly believed that the plaintiff was in wrong carriage even though he was in the right one. The porter thus pulled the plaintiff, as a result of which the plaintiff sustained injuries. Here the court held that railway company vicariously liable for the act of the porter because it was done in the course of his employment, and this act would have been proper if the plaintiff was indeed in the wrong carriage. In Anita Bhandari and others versus Union of India, the husband of the petitioner went to a bank, and while entering inside, the cash box of the bank was also being carried inside. As a result, the security guard in a haste shot him and caused death. The petitioner had claimed that the bank was vicariously liable in the case because the security guard had done such an act in the course of his employment, but the bank had contended that it had not authorized the guard to shoot. The court held the bank liable as the act of giving him gun amounted to authorize him to shoot when he deemed it necessary, and while the guard had acted overzealously in his duties, but it was still done in the course of his employment. Next, coming to wrong committed willfully by a servant with the intention of serving the purpose of the master. If a servant does not act willfully, recklessly, or improperly, then the master will be held liable for any wrong arising out of such an act, if such an act is done in the course of the employment. In Limpus versus London General Omnibus Corporation 1862, the driver of the defendant company willfully and against the express orders not to get involved in racing or to obstruct other omnibuses had driven to obstruct the omnibus of the plaintiff. In the case, the court held that the defendant's company was liable for the act of driver because the driver's act of driving the omnibus was within the scope of the course of employment. In Peterson versus Royal Oak Hotel Limited 1948, the plaintiff was a customer who, on being intoxicated, was refused further drinks by the barman, who was employed under the respondent, and thus the plaintiff threw a glass at him. The barman took a piece of the glass and threw at him, which hit his eye. The respondent hotel was held liable due to the act of the barman, who had a master-servant relationship with them. Lastly, coming to wrong by a servant's fraudulent act. A master can also be held liable for a fraudulent act of the servant. In Lloyd versus Gray Smith and Corporation 1912, the plaintiff was a widow who owned £1,000 as dues on a mortgage and a cottage. She went to the manager of the defendant, which was a firm of solicitors, and she asked for his advice to get richer. The manager told her to sell her cottage and to call up the amount of mortgage. She authorized the manager to sell the property and to collect her money, but she absconded with the money. Thus, she sued the defendant company. It was held that the defendant was liable for the fraudulent act of the manager because even a fraudulent act is not authorized. The manager was authorized to take her signature, and thus it was within the course of employment. For example, if A goes to a bank and deposits a check with C, an employee of the bank, and C fraudulently transfer that amount to his wife's account. Here, for the fraudulent act of C, the bank will be liable. And coming to the conclusion, under vicarious liability, a person can be held liable for the torts committed by another person if that person shares a master-servant relation with him. The servant does the act on behalf of his master, and therefore the law of torts provides that any wrongful act which is done in the course of employment by the servant is bound to make the master liable for it. There have been several tests for determining the relation of master and servant, and the court also applies its discretion according to the facts of the case to determine such a relationship.